Hello guys, good afternoon. Welcome back to another video with PRATHAM Test Prep. This is your host Sanjeet Bhatia, back again with another video today on the channel. Good afternoon Divyanshi, good afternoon everyone. So today I have selected some more legal affairs for you guys for CLAT 2022, AILET 2022 or any other law entrance exam that you're going to go next year itself, right? So first, the basic request that I do to all of you is to like, share, and subscribe the channel. If you haven't done it yet, do go and share and like, subscribe the channel right now. And you can also become a part of our Telegram channel, that is CLAT@Pratham. So you can definitely go and subscribe to our Telegram channel also, right? Now, if you have any doubts or if you want any test series or if you're looking forward for any kind of mentorship, you can definitely give us a call on 5x9 75392. That is our number. You can get in contact and you can find all the solutions to your test series and materials that you require. Everything will be available on this number. So starting with the session today, what is the basic thing that we are looking forward today is the legal affairs, right? What have happened in this past week? Few news is that can be important for your comprehension based sections. I'm going to discuss some of the newses of that sort today. Now, the first news is that the police force should have a secular image. No right under Article 25 for police personnel to keep a beard, right? So this is what the court has said. Allahabad High Court has come up with this, that keeping a beard is not any kind of protection that is provided under Article 25 of the Constitution of India, right? So what is being said by the Allahabad High Court, that there is no fundamental right under Article 25 for a police officer to keep a beard. Then next, there was a single judge bench of Justice Rajesh Singh Chauhan who dismissed the petition that was filed by one Muhammad Farman, a constable with Uttar Pradesh Police, who claimed that he has fundamental rights to keep a beard despite specific directions issued to the contrary by the superior authority. So the person was told by the superior authority to trim his beard, right? So, but there was a case that was filed by him inside the court regarding the same. Now, what did the court say in the matter? The court said that Article 25 guarantees freedom of conscience and free profession and practice and propagation of religion, right? Having a beard by a member of disciplined force may not protect it under Article 25 of the Constitution of India, right? So that is a basic thing that is being said by the court, that we are not going to save you if you want to keep a beard and if you are in a armed forces, right? Disciplined forces, as you may call. Now, Article 25 of the Constitution of India does not confer absolute right in this regard. All rights have to be viewed in the context and letter and spirit in which they were framed under the Constitution of India, right? So you shouldn't bring it on the table where it is not even required, right? That's what the court wants to say here, that Article 25 provides you all the freedom, but these rights have to be viewed in the right pretext, right? That is the basic thing that has to be kept in someone's mind before taking into consideration any of these laws. Okay, so this was the first case that can pop up as your exam comprehension based passage, so you can make sure that you are well aware about such integrities of the language also. Oh, I will check the Vamshi if it says, but it is, I will check the thumbnail. Definitely I will check the thumbnail and get it verified again and get it changed itself. Thank you, Divyanshi. Thanks a lot. Coming to the next is impact on mental health, right? And mental health, we have discussed a lot about our mental health in our classes also, and we have discussed a lot about mental health in our sessions also, right? So mental health is a very, very big issue right now in the whole society. So the impact on the mental health, the Bombay High Court permits termination of pregnancy of women who was initiated divorce after suffering domestic violence, right? So that is a very, very important thing. In doing so, the court said that it is the effect of pregnancy on mental health that needs to be taken into account under Section 32B1 of the Mental Termination of Pregnancy Act and not mental illness, right? So that is what is being said, that the effect of pregnancy on mental health that needs to be taken under account, right? and not mental illness. Mental health has to be taken into account. That is the most important thing that is being said here. Now, the bench of Justice Ujjal Bhuyan and Justice Madhav J. Jamandar held that declining permission to the petitioner who tantamount to compelling her to continue with her pregnancy, which in circumstance will not only be extremely burdensome and oppressive on her, but has the potential to cause grave injury to her mental health. Okay? If she's getting affected by it, if there's a mental health issue that is being caused to her because of the pregnancy or because of the child that she's carrying in her womb, then that should not be allowed, because one, it is already burdensome on her, and secondly, it's oppressive in nature. So ये दोनों चीजें बिल्कुल भी नहीं करनी चाहिए. So the court declined the permission to the petitioner, and they also initiated the termination of such pregnancy that it can be done because there is a mental health issue in this case. Now, coming to the next part of this whole scene is Shashi Tharoor case. So if you don't know, Shashi Tharoor is a member of the Congress party. There was a case where he and his wife was in a hotel, and the name of the wife was Miss Sunanda Pushkar. Mrs. Sunanda Pushkar committed suicide. Right now, there were a lot of speculations that were being caused here, but there was a statement that was given by the Delhi court is that there's no evidence that was found against Mr. Tharoor, right? That he acted in a manner which provoked or encouraged or incited Sunanda Pushkar to commit suicide, right? So that is what is being said by the court, that there was no act that was done by him in his regard so that she got encouraged to go and kill herself, right? Now they discharged Mr. Shashi Tharoor, and also relating and all discharge all his whatever cases were there related to the death of his wife Sunanda Pushkar also. And they said that there was no evidence that was found in the manner that he acted and provoked her. So all these cases are closed now. He's discharged of all the liabilities under this case. Now, there was a special judge whose name was Justice Geetanjali Goyal. In her order, she said that there was nothing on record to prove, and also that Mr. Shashi Tharoor acted in a way that irritated or annoyed or provoked Ms. Pushkar until she reacted, or for that matter, strongly persuaded or advised her to, so that she died by suicide. Okay, so the court has to be satisfied beyond the reasonable doubt. You have to understand that when you are reading things of this sort, you have to understand that when court is not accepting it beyond reasonable doubt, then they're not going to give a decision. But it has to be proved beyond reasonable doubt that there is a provocation that was done by him, or there has to be some reasonable more doubt that on him that he has done certain acts that led her to die. But there was nothing of that sort. So the Delhi High Court discharged Mr. Tharoor of all the charges that were there, and he is left on his own now. There is no charges against him for the death of Mrs. Sunanda Pushkar. Very simple case, but very interesting. You can go and read it. And it's been very, very long. It's been more than 8 to 10 years. I remember that this has been going on. So you should definitely read about it if you haven't heard about it yet. Now, the next thing is said by the Kerala High Court in this case is that there is no fundamental right to carry on business with state, right? Signing declaration form is not a necessary condition to award tender. That is also what is being said in this case. Now, what was happening in this case was regarding the GST. Okay, that is the goods and service tax. Now, what happened in this case, that the court said that the scope of interference by it in such matter is very restrictive, since no person can claim any fundamental right to carry on business with the state. Okay, that it is my fundamental right that the state has to give me a tender, or it is my fundamental right to do a trade with the state. That is no fundamental right. Okay, the Kerala High Court held that the signing of the declaration form with accurate GST details is not a necessary condition for awarding a tender and dismissing a petition challenging the award by tender by Kerala Minerals and Limited to a party who had not signed such declaration. ठीक है. So the declaration से कोई फर्क नहीं पड़ रहा है यहाँ पे, and it is not a fundamental right of a person to carry on business with the state, right? That was being said by the court in this regard. Okay, coming to the next case is the legal maxims that we are going to study today. Some legal maxim, I want to discuss some legal maxims also with a daily basis, so that you also get some new of them every time that we are discussing any news altogether. Now, the first is NEMO det esse judex in purpurea, right? Su causa. Now, NEMO det is no man can be judge in his own case, or no one ought to be a judge in his own cause. That was being said. Now, how can no one be in his own case? That if there is a benefit that the person can draw out of the case, right? Or is there someone he knows, or there is any relation to the person where the case is happening and who is on the judging side, then a person cannot be judge in his own case. There has to be total unbiasedness in a judge while he's giving a judgment. So there has to be no relation that he can draw. So no man can be a judge in his own case. No one ought to be a judge in his own cause can also be said in the meaning of this legal maxim very, very clearly, right? Now, coming to the next part is Nem puncher pro elino delicota. Delicoto is basically, one second, I'm really sorry. No one is to be punished for the crime or the wrong of another, right? It's a basic thing, right? If someone has done something wrong, other person shouldn't be punished for him, right? There has to be punishment has to be given to the one who's committed wrong, not to anyone else, right? So it's nemo punter pro elino delicuto. So these are all Latin terms. You can learn some of the Latin terms, but you cannot learn all of them. So these are the important ones that we will bring on the video so that you can also listen to them and learn them with time also. Now, and this is a bigger Latin term, so that even if they appear in your papers like AILET and other law entrances exam, where they want to make you learn all these maxims, then definitely you should know some of them at least, right? The next is Nova Constantio Futuri Forman Impora Debet Non Partiris. Now, what is happening in this is a new law ought to be prospective and not retrospective in operation. That is the basic thing. Okay. Most of the laws have to be made to be prospective until and unless, if you go to a law school, you will study that until and unless the law is there for in a beneficial nature, right? Then it can be put it in a retrospective manner. Until otherwise, it cannot be used in that manner. If you remember that we have discussed in our videos where the women have been made a co-partnership partner in their properties of their father. Okay, so that is there. Now the co-partnership partner, if they're made a co-partnership partner, that means they have equal rights in the property of their fathers, right? So that is what was said. So there is a retrospective effect of the law. That is what we have discussed in our previous videos. So this is also a legal maxim that is being used, because most of the laws are prospective in nature. They're not retrospective at all in nature. So this prospectivity is what is being defined under this section, under this maxim. But there can be laws which are retrospective in nature. They are beneficial laws, right? Beneficial in nature. So that is what you can say in this case also, that a new law ought to be prospective, not retrospective in operation. That is what is to be understood. The next is qui facet per alienum facet per se. He who acts by or through another acts for himself, right? So strict liability, right? Like a person, an employee, if you read in torts, that an employer is responsible for the acts of his employees. अगर आपके पास कोई ड्राइवर है और वो आपको लेने आ रहा है एयरपोर्ट पे और वो किसी को मार देता है, right? Like he commits an accident and kills someone, so then you will also be liable for that accident, because first he was under the course of your employment and he was completing the employment duties. Then definitely he has acted through you, right? If you had to drive your own car, but he's driving for you, so definitely you will be implicated in that matter itself, right? So he who acts by or through another acts for himself. So that is what is being said in the qui facet per alium facet per se is the name of the maxim that is in question here. So you can definitely learn this one also. Okay, so coming to the next one is quid pro quo. That means something for something, right? Something exchange for something. So that is also a very, very important maxim that you can find. Quid pro quo happens a lot in law, that something was given for something, that it can be used as a short term in your passages also, that quid pro quo happened, right? They gave something for something and you have to understand the meaning on your own. So this can be a very, very important term in your CLAT or any other law entrance examination, right? So I guess this is it for today, guys. I've given you a quick recap of 4 to 5 newses for the week, and also I've given you some of the legal maxims that you can learn. Sir, I could not crack CLAT. Should I go for CS? Sahil, you can go for CS. CS is a good option, but if you want to do law also, you can do law plus CS. That is also an option. If you want to complete your CS first, you can complete your CS and then you can go for a 3-year law course also. That is also 100% possible. It's called law after graduation. It happens in most of the traditional universities. DU-LLB is the best college to go for it. So if you are looking forward to going for CS, you can also look for your law after graduation. If anyone has any doubts, they can definitely put it on the chat box and I will be happy to help them out. If you are joining any colleges, also do let us know. We will help you out regarding the same. So definitely, Sahil, CS is a compliance officer, right? If you might know that compliance officer takes care of the rules and the regulations, and the companies has to work under the ambit of those rules and regulations. So a CS is a great option. And also, if you go for law first and you complete your law and then you want to go for your CS, then you are exempted from your first like the first stage of the CS exam that you have to give, the foundation one. You don't have to write the foundation course. So that's what you can do also, right? So that is also 100% possible in that matter. So I got into SLS Pune. Should I take a drop and give CLAT again? Divyanshi, I would say that you can go for SLS Pune. SLS Pune is a great option. Okay, if you feel like giving the exam again, you can even do it even if you are studying in SLS Pune, right? Because SLS being a great private university and a great option under the law school names, you can definitely go to SLS Pune. There is no harm in studying in SLS. If you still want to go to an NLU or you want to aim for CLAT, you can still study for it once you are there at the university also. So I would say that that's something that you can take care of. Divyanshi, so do go for SLS Pune. That is something that you can do. So sir, do these types of questions come in CLAT and AILET? Yes, legal maxims do come in CLAT and AILET. And we are also preparing you for the type of questions that can be asked in comprehension-based passages. So definitely, these kinds of questions can be asked to you inside the examination. So make sure that you are studying and reading a lot of blogs, or you reading a lot of newspapers and newses around you in the country, because they will help you a lot during the paper. Reading is one of the most essential things that are required for you to read before going for the CLAT or any other law entrance exam, right? So that would be it from my side. Thank you all. I hope you take care of yourself. Keep preparing, keep smiling, use your masks and hand sanitizers, and definitely maintain social distancing and keep safe, stay healthy. And thank you all for joining. We'll see you on Wednesday again with another video. And you can also put some suggestions of the videos if you want on YouTube. I will be making those videos for you guys so that it can get more interactive and you can also learn about the interested sections of CLAT and AILET. You are free to write your suggestions on the comment box. So do comment below and like, share and subscribe the channel. Thank you all. Take care, stay healthy and keep smiling. Bye-bye.